Well, it had to happen. 401k fees going to the highest court in the land. The Supreme Court set to hear its first ever case involving excessive 401k fees. The case was brought by current and former workers at Edison International who say the company was mismanaged their pensions. But do the workers have a case? Attorney Michael Becker and Fox News legal analyst Lise Wheels joins us now. Lise, what do you make of this story? I see this all the time. Companies, charging too high.
That's right. You've got 20,000 participants in this particular plan. And we know the 401ks, I think it's a $6.6 trillion business at this point. So they kind of blindly put their trust in the company and in these managers to invest at the appropriate level. There's something called, fiduciary duty of prudence. Exactly. They breach that. That's what the plaintiffs are saying here. They breach that by putting them in these higher funds with exactly the same benefits, but higher fees. Why? Because the managers can make money off of that. And that's what the Supremes are taking up.
Now, Michael, can you defend this company at all on their actions in this?
Well, no, I don't think the company can be defended, and I think that the Ninth Circuit clearly said that they couldn't be defended. The only issue really at stake has to do with the statute of limitations and whether petitioners can bring their cause or whether they waited too long to bring the action.
Can I just break in on that for a second? Because you're exactly right. That's the second issue in this, is whether the 6-year limitation should actually hold up. And I think the Supreme Court could be worried about expanding that definition of a limitation on when you're bringing a cause. But let's think back to the human perspective here. Sometimes you don't know that you have been dealt with incorrectly, that your managers, you don't know this. It takes a lot of time to bring a class action suit, which is what happened here. It can take that much. Sometimes you don't have money to hire an attorney. It can take years, and I hope the Supreme Court takes that into consideration.
What do you say, Michael?
Well, I think the Supreme Court will take that into consideration, and I think that they will evaluate whether or not fiduciaries or money managers have a continuing duty to make sure that they review investment strategies and that they divest from investments that are not the most efficient and that don't uphold their fiduciary obligations.
Okay, I just got to say, the example in this case where they got the wrong class in so you have several classes of shares in a mutual fund, A class, B class, C class. Everybody knows who's in the business that some of them carry monster fees and for no really good reason. And that's exactly what this company bought into. Lise, to you, how should this whole thing end?
I think the Supreme Court's going to look at both of the issues that we just talked about, the statute of limitations and also the duty, the prudence. And I think they're going to rule for the plaintiffs on this one.
Well, I guess we'll have to wait and see. Lise and Michael, thanks so much for your help tonight.
Thank you.